Okay, welcome everyone. So today we will hear the case of Royal Furniture against Tosca Mobili and Swift. I presume both parties are present in court. Okay. We have 1 hour allocated for you today. Perhaps you can indicate the time, how you would want to devise this time. Can you quickly state this for us, or you will do it later?
Thank you, Your Honor. So I will be the first speaker for the respondent, Tosca and Swift, and I will use 16 minutes for jurisdiction and respondents. My co-counsel will address the issue of applicable law in a 12 minutes submission, and we reserve 2 minutes per hour.
Okay, perfect. And for the respondent?
Yes, Madam President. The applicant will take 90 minutes regarding the first and second questions, which I will be pleading, and my co-counsel will take 10 minutes regarding the applicable law, and we would like to reserve 1 minute for the law.
Okay, perfect. Just some preliminary remarks before we start. As you can imagine, the court has prepared the case. We know the facts. So please stick to the judicial arguments, where of course you will use the facts, but do not spend too much time on expanding on the facts. Today we will also only address the issue of the competent court and the applicable law, so there will be no arguments on the merits of the case. And then last remark, perhaps the most important one, we judges, we tend to have a kind of Cartesian judicial mind, meaning that we would like all the arguments substantiated with articles of the legislation, if relevant, or the relevant case law.
Sorry. Can you hear me? Yeah.
Yes, no problem.
Okay. Madam President, honorable members of the court, it is a great honor for me to appear before you today. My name is Elena Limonova, and alongside my co-counsel, Mr. Krumov, I have the honor of representing the applicant in the present proceedings, namely Royal Furniture OD. You know, it's no surprise that I'm representing the applicant in the present proceedings, since the applicant is the Bulgarian entity in the case in the end. In the following 19 minutes, I will address the first and second questions, and my co-counsel will address the third question regarding the applicable law. Your honors, in a world where commerce crosses borders as easily as promises are made, private international law and its principles stand to ensure that those promises still mean something. Yet, the applicant is faced with a chain of broken commitments. From Tosca, not using ethical materials for the production of its furniture, to Swift leaving the consignment at an unattended parking, all of which resulted in impaired reputation and damages. To ensure clarity, I will start with the dispute between Royal and Tosca, and will prove that the applicable regulatory framework leads to Sofia Court. First, Regulation Brussels 1 bis is the applicable source for the dispute between Royal and Tosca. The dispute is a civil and commercial matter within the meaning of Article 1 of the regulation. Additionally, the domicile of the defendant is in a member state, as Article 63 requires, and the regulation is applicable ratione temporis as well. Applicant's position for the conflict between Royal and Tosca will be divided into 3 alternative arguments. Sofia Court has jurisdiction under Royal's terms and conditions, pursuant to Article 25 of Regulation Brussels 1 bis. Alternatively, Sofia Court has jurisdiction under Tosca's jurisdictional clause, pursuant to Article 25 Regulation Brussels 1 bis. Or, in the alternative, Sofia Court has special jurisdiction under Article 7, Paragraph 1, Letter B, First Indent of Regulation Brussels 1 bis. The jurisdictional agreement between Royal and Tosca meets all formal requirements set out by Article 25 of Regulation Brussels 1 bis and CGU's extensive case law. Those formal requirements aim to guarantee, on the one hand, that consent between the parties is present, while also taking into consideration modern electronic methods for faster and easier conclusion of contracts. Those requirements are explicit reference to the terms and conditions containing the jurisdictional clause and possibility of a durable record of them prior to the conclusion of the contract. According to the Elmers-Dub case, whether the terms and conditions were actually opened or downloaded by the other contracting party is irrelevant, as long as they had the chance to do so. Moreover, whether the page containing the terms and conditions opens automatically is also irrelevant.
Okay, I perhaps already would like to interrupt. So pivotal is whether there is a written agreement or not. And that written agreement may be on an electronic device. But where do you find this written agreement of the jurisdiction clause? I mean, agreement is both parties agreeing to a jurisdiction clause. And so you refer to the Majub case. There you explicitly had to click acceptance with the jurisdiction clause. So is there case law that substantiate your view that in the facts that we have at hand, an exchange of emails, that at one point there's an agreement, a written agreement?
Madam President, there is no written agreement between the parties regarding the jurisdictional clause. That is why the present case is of such complexity. However, in the Tillman case, the court holds that a jurisdictional clause does not need to be accepted by ticking a box, but a hyperlink providing access to the terms and conditions containing the clause is sufficient in ensuring that those terms and conditions were actually a subject of consensus between the parties.
I think my co-jury has a question.
Well, I will have to stop you right there because I think you're turning in a circle here. You're talking about formalities, which, yes, are important, but Madam President's question was whether we can find the agreement, because according to the ECJ's case law, there must be real consensus between the parties, which has to be clear and precise. And this is what we are struggling to find out. Can you help us with that? Not the formalities, not about clicking, not about terms and conditions. Where do you find the wills of the two parties coming together into a real consensus? That is the question.
Your Honor, the CGU held in the Sawoti case that the formal requirements to a jurisdictional agreement exist precisely to ensure that consent between the parties is present. Moreover, according to our case, Mr. Medvedev, in his email from the 26th of May, did explicitly point Royal's terms and conditions as applicable to the contract between Royal and Tosca. And although there was no written confirmation of Tosca regarding the applicability of Royal jurisdictional clause, there was also no objection on Tosca's side.
So it's a bit difficult with just one
Yeah.
micro, but so you do acknowledge that there was no agreement from Tosca. So if you acknowledge that, therefore, your argument just fails, because there's no agreement. Now, you're saying there was no objection. That's a different argument. Are you saying that agreement could be implicit? Is that your argument?
Yes, Your Honor, in the present case, we submit that Tosca had 2 months to object to Royal's terms and conditions.
Okay. Now, can you explain to us how is an implicit agreement compatible with the Court of Justice's case law, Al-Majdoub case, which requires clear and precise agreement? How is an implicit agreement clear and precise?
Yes, in the follow-up, I would like you to explain perhaps the difference with the Tillman case that you referred to.
I'm sorry, would you...
Well, could you elaborate on the facts of the Tillman case and indicate why it is different from the facts that we have at hand?
Yes, Your Honors. In the Tillman case, replying first to Ms. President's question, in the Tillman case, there was, in fact, a written sales of contract of sales between the parties, which contained express reference to the terms and conditions containing the jurisdictional clause. However, and in the Elmers-Duke, there was acceptance of the terms and conditions by click wrapping. However, the Tillman case builds upon what the court has held in the Elmers-Duke case and states that as long as there is explicit reference to those terms and conditions and the other party was actually apprised of the fact that those terms and conditions were existing, the other party had the ability to check the terms and conditions, to durably record them by printing or saving them. Hence, this is enough, according to the CGU's case law, to establish consensus between the parties. And there is no precise requirement of the CGU that the jurisdictional clause or the jurisdictional agreement between the parties should be precisely written. It should be evidenced in writing, which is the present case, since according to, we submit that the jurisdictional agreement between the parties was in the present case concluded in an electronic form by their, by the fact that they exchanged different emails.
Sorry, just to simplify your argument, just get to the point, please. Are you saying to this court that no objection equals agreement within the meaning of Article 25? Is that your argument?
In this precise case, we state that, yes, the fact that Tosca did not object leads to consent.
Thank you. Move on.
Okay.
According to the case, moreover, Ms. Claro opened the hyperlink of Royal, meaning that the link was functioning, which is one of the requirements of the CGU, in order that the terms and conditions were actually communicated to the other party, is that the hyperlink leading to those terms and conditions functions and could be activated. In our case, the present link functions, hence the terms and conditions were in fact communicated to Tosca. Respondent may still try to invoke that Tosca's terms and conditions should apply instead of Royal's. They may try and say that Mr. Medvedev accepted them with his conduct, instructing his bank to issue a letter of credit on the 24th of May. This brings me to my alternative argument, that even under Tosca's jurisdictional clause, Sofia Court still has jurisdiction. I invite the court to open on page 2, under the second table, where you can see Tosca's jurisdictional clause. The court at the place of performance, or the court in Milan, shall have jurisdiction. Now, the relevant question is, which is the court at the place of performance? Madam President, distinguished members of the court at the place of performance is undoubtedly Sofia. The CGU has interpreted the term place of performance under the contract in Electricity Europe case, although there the interpretation was in line with special jurisdiction.
So just a clarification. So your second alternative argument basically falls back on your third alternative argument, which is again on place of performance. Is that the same thing?
No, Your Honor. What we are implying is that simply we are interpreting the term place of performance in Tosca's jurisdictional clause in line with the existing CGU case law.
And what did the court exactly say in Eurosteel? Did it say that an Incoterm is sufficient?
Yes, Madam President.
Is that the exact wording of the court? In Eurosteel, is that what they said? Didn't they say you have to take account of the whole, the contract as a whole? All the terms, and the Incoterm can be an indication? And so if you look here, we have two Incoterms.
Madam President, I see your concern. In the Electricity Europe case, the CGU indeed held that court shall take into consideration all provisions of a contract, including Incoterms clauses. In our case, there are two Incoterms clauses. However, we submit that there are also two separate contracts between the parties, one for the 6 tables and 6 cabinets, and one for the 14 tables and 6 chairs. This is due to the fact that the whole case refers to the contracts as two separate contracts. The proceedings were initiated against Tosca on the first hint, only in regards to the 6 tables and 6 cabinets. Moreover, in paragraph 8 of the case itself states the tables and the cabinets. After that, there is a clear reference that the case itself differentiates both contracts, since in paragraph 14 of the case starts talking about the chairs and the sofas. Hence, we submit that there were 2 separate contracts between the parties. And the mere fact that later on 6 items were delivered in Rijeka does not alter the jurisdictional agreement between the parties. The CGU in the CIA home case maintained that a jurisdictional agreement could not be established without some written confirmation. Hence, in the present case, a single phone call does not alter the jurisdictional agreement between the parties, and Sofia Court is still the court at the place of performance of the goods. Hence, Sofia Court has jurisdiction under Tosca's jurisdictional clause as well.
Yeah, if this court were to disagree with you on your argument that there are 2 separate contracts, if we were to decide that those 2 contracts actually make one whole commercial relationship, which between the same parties, it's the same correspondence at the same time, etc., what would be your alternative argument in that scenario?
In that scenario, our alternative argument would be that the jurisdictional agreement was actually under Royal's terms and conditions, which explicitly refers to Sofia Court.
So your second alternative argument is based on the premise that there are 2 separate contracts. So if we disagree with that premise, your second subsidiary argument fails.
Your Honor, our first argument, all our arguments are alternative. However, we deem some precedence over the first argument that we submit, that the contract was concluded under Royal's terms and conditions. And for all our arguments, we submit that the contracts were 2 separate contracts. Our interpretation of the facts of the case does not change in regard.
Yeah, I understand that, but you have to give us a solid argument if we were to disagree with you that there are 2 separate contracts. Because if we disagree with you, then your whole thesis just falls to pieces.
The second one. So perhaps, yes, you could proceed with Article 7.
Thank you, Madam President. Now, Respondent may try to argue that there was no consensus between the parties on either of their jurisdictional clauses. Consequently, there is no prorogation. However, even if there is no prorogation, Sofia Court still has special jurisdiction under Article 7. Article 7 presupposes as a preliminary condition the existence of general jurisdiction under Article 4 of the regulation, which is complied with in the present case since Tosca is domiciled in Italy, Milan. Letter B of Article 7 first indent requires a contract for the sale of goods, which is complied with in the present case too.
If you say there are 2 separate contracts, is it still a sale of goods, the manufacturing of these tables and cabinets?
Yes, Madam President. The CGU in Cartram states that a contract is one for the sale of goods, despite the buyer's specifications for the product, as long as the materials were supplied by the seller, and the seller took responsibility for providing ethical materials. In our case, Tosca specifically pointed out in paragraph 5 that they have the required materials available and took responsibility for providing ethical materials. Hence, the present contract is one for the sale of goods. Concerning the place of performance of the goods, the first indent of Article 7 designates it in the place where, under the contract, the goods were or should have been delivered. As previously mentioned, in Electricity Europe, the CGU maintains that when determining jurisdiction, the place of performance under the contract shall be determined by national courts, taking into consideration Incoterms clauses used by the parties. And in our case, the parties designated the delivery with an Incoterms clause, DAP Sofia. Yet, it is true that later on 6 items were delivered in Rijeka. However, in Color Drag, the CGU maintains that when no principal place of delivery could be established based on economic criteria, as is the present case, since the delivery was split equally, then the plaintiff may sue the defendant in the courts at the place of delivery of its choice. When, however, the deliveries took place within a single member state, that is in color drag. However, according to the Rader case, such interpretation is also valid when the deliveries are not effected within a single member state. And although the Rader case concerns the provision of services, the CGU held that the rules of special jurisdiction for both provision of services and sale of goods contract have the same origin, pursue the same objectives, and occupy the same place in the scheme of the regulation.
But so there hasn't been case law yet on this specific point of different places of delivery of a sale of goods in different member states?
That is the color drag case. No, in different member states.
No. So should we ask the court? I mean the Court of Justice?
Madam President, we could apply the interpretation of the Court in Justice in regards to provision of services contracts accordingly to sale of goods. As mentioned that in the Rader case, the CGU held that both rules for special jurisdiction have the same origin and the same objectives.
I also wanted to just to interrupt because you're looking again on premised on the fact that according to you there are two contracts. So only looking at the first one, correct? Okay. So you're saying that we cannot identify a principal place of delivery. So therefore there are two places of delivery. So you have the choice. Is that so? Right. So my question then is: would the Sofia Court then has jurisdiction to adjudicate on both deliveries, or only on the delivery which happened in Bulgaria?
Your Honor, in the color drag case, the court held that when deliveries are split, it is important that a single court renders according to both deliveries in order to contain the objectives of proximity and to not have irreconcilable judgments again.
But didn't the court say that in relation to the importance of identifying one principal place of delivery? Or did it affirm that in relation to when you have like two or three places of delivery, when you cannot identify a principal place of delivery? And how would that then be justified with regard to the principle of proximity? How can the Bulgarian court adjudicate on whether or not the merchandise which was delivered in Croatia was damaged, and what was the damage?
Your Honor, the obligations arise from the same contract, and what the CGU examined is in order exactly to uphold the object of proximity and predictability in allocating jurisdiction, that when no principal place of delivery could be established, then the applicant may choose which courts to sue.
I understand that. My question is on the substance. Okay, so you've chosen the Bulgarian court, and your argument is that the Bulgarian court will have jurisdiction on both deliveries, so to speak.
Yes, Your Honor.
So how does that correspond to the principle of proximity? Because that means that the Bulgarian court is in the best situation to adjudicate on the facts, on the evidence, and the evidence on the quantification of the damage is somewhere in Croatia.
However, what the CGU also used as a linking factor was the closest linking factor to the court that shall have jurisdiction according to the deliveries. And we submit that Sofia Court, as one of the places of delivery, is closely connected to the contract. And hence, Sofia Court shall have jurisdiction. I am now turning to our second submission, namely that Sofia Court has jurisdiction over the dispute between Royal and SWIFT II. CMR is the applicable source for this dispute since the parties concluded a carriage contract from one contracting state to another. The applicant submits that the court in Sofia has jurisdiction under Article 31, Paragraph 1 of the Convention, based on the jurisdictional agreement between Royal and SWIFT. According to the commentary on the CMR, an exclusive choice of court under Article 31, paragraph 1, as is the exclusive choice of court between Royal and Swift in the present case, displaces the other grounds for jurisdiction and is thus null and void under Article 41 of the CMR. However, Professor Schermer suggests that an exclusive choice of court under Article 31 may be interpreted as non-exclusive to uphold the will of the parties. Hence, Sofia Court has jurisdiction over the dispute between Royal and Swift based on their jurisdictional agreement.
I'm sorry, yeah. This was not very convincing because you just said that there was, on the one hand, arguments that the jurisdictional clause is exclusive. On the other hand, you quoted some academic work that says otherwise. Do you think that's enough to support your argument?
Your Honor, there are also national cases of the Austrian Supreme Court, also of the Bulgarian Supreme Court, that such an exclusive choice of court may be interpreted as non-exclusive in order to be a ground of jurisdiction under the CMR. However, we are not allowed to rely on those. And in case the Honorable Court does not sustain that the jurisdictional agreement shall be deemed as non-exclusive, Sofia Court still has jurisdiction as the designated place for delivery under...
Could we, if we have doubts about the correct interpretation of the CMR, could we refer the matter to the Court of Justice of the EU on interpretation of that specific article of the CMR?
I'm sorry, no, Your Honor, you could not bring your concern to the CGU since the European Union is not the contracting party to the CMR and the Court of Justice does not have jurisdiction to interpret the provisions of the CMR. What the Court of Justice has interpreted in its case law is essentially Article 71 of Regulation Brussels 1 bis, which brings me to my last submission, that the Rotterdam Court shall stay its proceedings because under Article 71 of Regulation Brussels 1 bis, specialized conventions...
Could we, before agreeing on this stay of proceedings, can you, if we do not follow your reasoning about this exclusive character of the prorogation clause as allowed under the CMR, what would then the solution be if we agree with your doctrine, your professors, and the other case law? What happens then?
Then Sofia Court is also competent as a designated place for delivery under letter B of Article 31 of the CMR. Moving to my last submission, we submit that the lis pendens regime of Regulation Brussels 1 bis should be applied, since it better upholds the will of the parties, thus providing for legal certainty, predictability, and elimination of irreconcilable judgments. Moreover, applying the lis pendens, may I please finish my sentence? I will, thank you. Applying the lis pendens regime of Regulation Brussels 1 bis leads to the applicability of Article 31, paragraph 2 of Regulation Brussels 1 bis, under which the court that was not designated by the parties shall stay its proceedings, and Sofia Court, as the one designated by the parties with an exclusive jurisdictional agreement, shall proceed.
Okay, we have one more question.
Question here. Yes, concerning the lis pendens issue. Now, let's imagine that the court in Rotterdam, because of some reason, they disagree with your understanding of the law or whatever, will say, no, we keep our jurisdiction, we proceed. Where does it leave your client? What are options of your client then?
Your Honor, that is precisely one of our points, that if the Rotterdam Court renders a decision before Sofia Court, as the court designated by the parties, Sofia Court's decision will be problematic according to the recognition of Sofia Court's decision under Article 45 of Regulation Brussels 1 bis, which is one more point that helps the applicant that the Regulation Brussels 1 bis should be applied, since it takes account of exclusive choice of court agreements, which is not something taken into account by the CMR.
But I mean, if we are reached by the information that the Rotterdam Court has held that they continue, you know, what would you do here in the Court of Sofia? Would you proceed to Or would you stop and stay?
I see your concern, Your Honor. According to Recital 22 of Regulation Brussels 1 bis, the court that is designated by the parties may proceed regardless of whether other courts of member states continue with their proceedings, or regardless of whether they stay their proceedings, etc.
Okay, I think we should move on to the applicable law.
Madam President, honorable members of the bench, my name is Michiel Krumov, and on behalf of the applicant, I will address question number 3 of the case, namely the issue of applicable law. The applicant is well aware of the ambiguity and the complexity that arises from communication by email, including in the present case, particularly with regard to the choice of law clause. And yet, Your Honor, this case is not one of uncertainty, but rather one that turns on the principle of party autonomy. And in light of this very party autonomy, our submissions today focus on 2 key issues. First, to the exclusion of the CISG from the contracts between Royal and Tosca, and second, to the choice of applicable law, where we submit that the parties have validly agreed on the applicability of Bulgarian law to their contracts. Both submissions are based on one and the same condition, and that is the incorporation of Royal's terms and conditions into the contractual framework between the parties. With that, allow me to turn to the first issue, namely the exclusion of the CISG. The contracts...
Could you just clarify before you start your argument, are you going to make the argument under the rules of the CSG, the Vienna Convention, or are you going to apply like the Rome regulation and say we're using the choice of law and applicable law?
Yes, Your Honor, we are going to address the issue precisely under which rules we are going to determine the validity of the clause. But if you...
well, can you just answer it?
Yes, so on the one side, one could argue that the exclusion is to be assessed, the validity of the exclusion is entirely a matter of the private international law of the forum, which is, among others, shared by Peter Schlechtrim, as well as several contracting states' national courts.
But what is the priority? No, I'm going to let you finish your argument, sorry.
Thank you, Your Honor. So on the other hand, there is the view that the formation of such an exclusion is governed by the rules on contract formation of the CSG, namely Articles 14 to 24.
And what takes priority? Is there a priority rule between
Yes.
the regulation and the convention?
This is, the second view is supported by what seems to be the majority opinion, and that is what we also maintain, among others by Franco Ferrari, Ulrich Magnus in the Staudinger commentary on EU private international law. And although in the present case such dispute would be obsolete in the light, in view of the fact that the exclusion is, we maintain, valid both under Rome I and the CISG, we firmly maintain that in view of the ipso jure applicability of the convention, the validity of the exclusion under pursuant to its Article 6 is to be determined under its own provisions.
Okay, and not according to Article 25 of the Rome I.
Well, it allows for specialized conventions to apply, and in this case, Your Honor, as the contracts between Royal and Tosca both qualify as such for the sale of goods within the meaning of the convention, and thus fall within its material scope, and also both parties are located in contracting states, the convention seems to apply. However, this is true only to the extent that the parties have not excluded it pursuant.
But we start the legal reasoning starting from...
We start from the CISG and the exclusion of the CISG.
Thank you.
Yes, so now first allow me to examine the validity of the exclusion under the rules on contract formation of the CISG, and then I will turn to the issue of applicability of Bulgarian law under the Rome I regulation. Although the current version of the CISG does not directly speak of an implicit derogation, it is widely accepted both in the national case law and in the legal doctrine, for instance, Franco Ferrari, as well as the Unicitral Digest in its Article 6, paragraph 6, that courts should apply Article 8 of the Convention and the CSG's autonomous standards when interpreting the exclusion agreement. In the present case, Your Honors, Royal explicitly referred to their terms and conditions in the body of Mr. Medvedev's email from May 26, 2025. As you can see in paragraph 4 of the case, those terms and conditions clearly designate Bulgarian law and explicitly exclude the CISG. They are accessible through a hyperlink, which is contained in the signature section of the email. The legal doctrine, including the authoritative analysis of Professor Peter Huber in his textbook on the CISG, as well as Advisory Council Opinion number 13, confirms that the exclusion of the CISG may validly occur through such standard terms, provided that those terms were validly incorporated into the contract.
And isn't it possible, it's just a remark, that your footer might give rise to some uncertainties? Because you seem to contradict yourself, or your client at least, that on the one hand they refer to Bulgarian law as a whole, and then explicitly in the terms and conditions they say with the exclusion of. So what is it?
Your Honor, I completely understand your concern. However, we rely entirely on the explicit reference to the terms and conditions in the body of the email and not the reference that is contained in the footer section. So Tosca did not object to this reference made by Royal. On the contrary, they continued with the performance of their contractual obligations, as you can see from paragraph 8 of the case, where Ms. Claro, which is 2 months after Mr. Medvedev's email, confirmed by email of July 25th, 2025, that the goods were ready for delivery. Article 19, paragraph 1 of the Convention of the CISG governs the mechanism of contract formation. And under that provision, a reply to an offer that contains additional or different terms constitutes a rejection of the offer and constitutes also a counter-offer. If the contract is then executed, the terms and conditions that were most recently mentioned or referred to shall become part of the contract. If the parties wanted to avoid this rule, for instance, they could have incorporated the unidroit principles, for instance, Article 2.1.22, which explicitly incorporates the so-called knockout rule. This view is supported, among others, in the legal doctrine by Burkhard Pilz and Mario Stucki, as well as various national courts. And thus, Your Honor, the reference in Mr. Medvedev's email to the terms and conditions, which were accessible via hyperlink, represents a proposal to exclude the CISG. And the majority of the doctrine, including Felix Lautenschlager, Ulrich Schröter, as well as Advisory Council Opinion 13 in paragraph.
Okay. I was just wondering, can the argument not be made that perhaps there was already a contract concluded by the payment?
Your Honor, we maintain that the contract was not yet validly concluded. As you can see in paragraph 7, Royal instructed the bank to issue the letter of credit on the 24th of May, which, according to the official calendar for 2025, it was a Saturday. So the following day was a Sunday, and the day after that, in Bulgaria, in the Bulgarian banks, it was a holiday as well. The bank could have not processed this letter of credit, and also in view of clarification question 57, the other party, being Tosca, they did not yet know of that payment. Therefore, we maintain that the contract was validly concluded with Mr. Medvedev's email, as in paragraph 7.
Mm-hmm. Okay. Now, you refer to this advisory opinion, but what is the legal value of this?
The Advisory Council is a private body that provides uniform interpretation of the CISG, as there is, for instance, as in difference to the EU regulation, there is no single court that interprets its provisions, so it aims to unify the applicability, and it is of great doctrinal value. In its paragraph 3D, it supports that such incorporations through an electronic link should be sufficient. At the same time, Tosca's conduct, particularly the performance of their obligations under the thus proposed agreement, constitutes acceptance of this offer. Moreover, the Advisory Council Opinion 13 argues that implied acceptance of terms and conditions should be taken into account, where there is a clear reference to those terms and conditions, when they are reasonably available for the other party to consult them, and when the offeree starts performing without objection. And second, now let me examine the validity of the choice of law clause under the Rome I regulation. So under Article 3, paragraph 1 of the Rome 1 regulation, parties are free to choose the law that applies to their contract. This choice may be made expressly or clearly demonstrated by the circumstances of the case or the terms of the contract. It may be also agreed on after the conclusion of the main contract. And also under Article 3, tacit acceptance must be taken into account, which view is also supported in the doctrine, including Professor Jan van Heijn, in the Rauscher commentary, Ulrich Magnus and others. And such acceptance of the choice of law clause is to be determined in view of the conduct of each party. And here, Your Honors, I would like to draw your attention to the following circumstances. First, as regards to Royal's proposal, Royal's terms and conditions were expressly referenced in the body of Mr. Medvedev's email and contained a clear and comprehensive choice of law clause. Second, to Tosca's conduct, which is a combination of silence as to Royal's proposal and performance of their obligations under the thus proposed agreement. Tosca performed without objection, which is also evident from Ms. Claro's email. Furthermore, this happened 2 months after the mentioned email from Mr. Medvedev. And finally, as my co-counsel previously argued, the parties agreed on a choice of court clause, which, although not sufficient by itself, in view of recital 12 to the Rome 1 regulation, should be one of the factors to be taken into account when determining whether a choice of law has been clearly demonstrated.
Okay, I was just wondering, what do we do with this last email of Tosca? Just explicitly referring to Italian law?
As we already argued, we do not rely on the footer section of the email. It came after the performance came. First, we can see in paragraph 8 that Tosca had already proceeded with the performance of their obligations, and this email came only as confirmation where she stated that the goods were ready for delivery. All these factors taken together should lead to nothing but a clear-cut example of implicit choice of applicable law. In conclusion, on behalf of the applicant, we maintain that the parties have validly agreed, and the court in Sofia has jurisdiction, and the parties have validly agreed on the choice of Bulgarian law and with the exclusion of the CSG.
Thank you very much. Sorry, one more question.
I think I can ask a question.
Yes.
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 I don't know if I'm allowed to go back to the question of litispendence.
Yeah.
Yes? Because I thought that because we were running out of time, and that question was
We can
sort of
allocate
very
5 more
briefly
minutes.
addressed.
Yes.
Would that be okay, Madam President?
Yes, it would. We will also give the respondent an extra 5 minutes.
Thank you. Because I think there was this immensely important question. Because you seem to argue that the litispendence rule under the Parsons 1 regulation takes precedence over the litispendence rule in the CMR, correct? In order for you to do that convincingly, I need you to convince us that AG Emilio got it wrong in his opinion. Yeah. Can you do that briefly and very convincingly, because you would be arguing against an Advocate General's opinion?
Yes, Your Honor. I am well aware of Advocate General Emilio's opinion. However, we submit. I'm sorry. Just a second. I'm really sorry, but okay. Yes, indeed, according to Advocate General Emilio, the principles of Regulation Brussels 1 bis are not undermined by applying the CMR, since CMR's own litispendence mechanism does not compromise the sound administration of justice. However, we submit that in our case, the parties have concluded an exclusive jurisdictional agreement in favor of Sofia Court. This in turn, and according to the TNT case, applying a specialized conventions within intra-EU situations could not lead to less favorable results for the parties other than those which would be produced under the regulation. In our case, applying the litispendence regime of the CMR clearly leads to results less favorable for the parties, as their will to choose a particular court would not be upheld. This in turn puts it...
This leads to less favorable results for you, but not to the other party.
However, this also puts at risk the principles, in this specific case, the principles of legal certainty, since the parties could not clearly foresee the competent court. Second,
The AG says the contrary. He says, no, there is legal certainty because you can clearly identify several
Yes.
places of jurisdiction.
that is true. However, in the Yensidige case, the court argues that it could be interpreted that under Article 45 of Regulation Brussels 1 bis, as already mentioned, if the Rotterdam court renders a decision that was not by the court designated by the parties, this would put a problem to the decision of Sofia court regarding recognition of the judgment under Article 45 of Regulation Brussels 1 bis. Moreover, the principle of predictability is put at risk by not upholding the will of the parties, since courts could not quickly determine jurisdiction without going to the substance of the case. And third, the elimination of irreconcilable judgments, which is a main objective of Regulation Brussels 1 bis, is put at risk, as a court other than one designated by the parties may assume jurisdiction.
I understand that. If you had to choose
Okay.
the strongest argument to rebut AG Emilio, just one argument, your silver bullet, what is it?
That the principles of Regulation Brussels 1 bis are better upheld by applying the regulation itself.
Which principle?
Okay, and then we have to.
We have to wrap up, but I just really want you to get to the point.
Legal certainty,
Legal certainty would be your main argument.
yes, and predictability.
Thank you.
Okay. Thank you very much. It remains, of course, a pity that the court did not address this question, but we will see what the respondents' view on the matter are. Madam Timekeeper, you kept correct. Okay, so you have the right to 5 extra minutes. How will you allocate them?
I will use 2 additional minutes regarding the jurisdiction and lispedance, and my co-counsel will make 2 additional minutes regarding the applicable law.
Okay, this is noted. Okay, so please proceed.
Madam President, honorable members of the court, and respected representatives of the respondents, I wish you all good afternoon. My name is Maja Kozina, and together with my co-counsel David Golop, we represent respondents in these proceedings. I will address the question of this court jurisdiction, and lispedance, my co-counsel, will address the question of applicable law. Honorable members of the court, can the respondents truly be expected to defend themselves where jurisdiction is left entirely at the mercy of the applicant choice, or is based on a clause that cannot even operate under the governing convention? That is precisely what the applicant asks this court to accept. That is not legal certainty or honors, that is litigation strategy, and the unpredictability the respondents face today. Against this backdrop, I will follow the structure of the opposing counsel and first demonstrate that this court lacks jurisdiction over Tosca Mobile, and then show that in light of lispedance effect regarding SWIFT, these proceedings must be stayed. So turning to the first issue, I will first address the opposing counsel's argument on Article 25 of the Brussels 1 bis, and then proceed with Article 7 of the Brussels 1 bis regulation. So turning to the Article 25. The opposing counsel is claiming the jurisdiction clause between applicant and Tosca was agreed upon, firstly, with applicant providing its general terms and conditions in paragraph 7 of this case, or with applicant providing its jurisdiction clause, that is place of performance or the court in Milan, and the respondents issuing the letter of the credit, or the applicant issuing the letter of the credit. However, members of the court, neither of those jurisdiction clauses were expressly accepted by the respondents. Even the opposing counsel noted that there was no written confirmation to such jurisdiction clause, and therefore, as the court emphasized, the opposing Council is claiming that implied consent is sufficient to conclude a jurisdiction agreement. However, members of the Court, under the Brussels 1bis regulation, implied consent to jurisdiction agreements is only valid if it satisfies the form requirements of Article 25. And under Article 25 of the Brussels 1bis regulation, jurisdiction agreement can be either concluded in writing or in a form that corresponds with practices between the parties. Do I sense a question, Madam President?
No.
So, against this backdrop, I will demonstrate first that this agreement was not concluded in writing, nor can be correspond to the practices between the parties. So firstly, neither the performance of the contract, that is issuing the letter of credit, nor silence to providing general terms and conditions by the respondent can be regarded as agreement in writing to jurisdiction clause under Article 25. Jurisdiction agreement to satisfy the form requirement of writing, both parties have to express their consent to specific jurisdiction clause in written form. The opposing counsel is relying on a CJU case law such as El Maidoub case, Tillman case. However, in both of these cases, there was an active acceptance of a parties to jurisdiction clause. For example, in El Maidoub, the party clicked a box on a website accepting general terms and conditions. It is true that in Tillman case there was no such requirement. However, members of the Court, in Tillman case, both parties signed the contract. So in neither of those cases there was either silence to confirmation letter or the performance of the contract that constitutes an agreement. So accordingly, under that basis, it is established in the commentaries that if a party accepts in writing the written offer of the other party, but attaches each general terms and conditions, it was precisely in the present case, the written consent is lacking unless the other party then again accepts these modifications. And accordingly, even if there is an offer provided and the other party performs the contract, there is no written agreement to jurisdiction clause.
I do have a question. Could the argument be made that as your client did actually the same, so put a choice of court in its terms and conditions, whether that would be a valid choice of court agreement or not?
Madam President, could you maybe just repeat?
Yes, is the choice of court that your client proposed or indicated in its terms and conditions, would that be a valid choice of court agreement?
Thank you, Your Honor. So the respondents did not provide additional jurisdiction clause in their general terms and conditions. They only provided jurisdiction agreement in their email correspondence, and that is stating the place of performance or the court in Milan. However, I would first like to emphasize that the court at the place of performance cannot be so easily determined that this is the court in Bulgaria, how the opposing counsel is claiming, since there were multiple places that could be determined as the place of performance. As they mentioned, half of the goods were delivered to Croatia, some of the goods were delivered from the Rotterdam, and also, according to clarifications of the case, the whole manufacturing process took place in Italy. However, it is not clear that place of performance is Bulgaria. However, even if we considered place of performance Bulgaria, as I mentioned, issuing the letter of credit cannot be relied upon as acceptance to such a jurisdiction clause by the applicant.
Okay, so you did not make a choice of court agreement yourself, your client?
That is correct, Your Honor.
Okay.
So accordingly, I would...
Yeah, just to make sure I understand your argument, are you saying that in principle, as a matter of law, implied consent would never be sufficient for the purpose of Article 25?
Thank you, Your Honor. So this is precisely my second submission regarding this agreement. So implied consent could indeed suffice for Article 25 in some cases, as it was established in Gallery Segura case by the CJU and also MSG case. However, in that cases, the CJU acknowledged implied consent. However, the court emphasized specifically that that may constitute a jurisdiction agreement only if that corresponds to practices established between the parties. So accordingly, if I point the court to clarification number 37, this is the first joint transaction between applicant and TOSCA, and therefore there is no such established course of dealings between the parties. It would be unfair and unpredictable to then imply such a consent and form a jurisdiction clause rather than rely on the default rules of Brussels.
Then why didn't your client object? Because in the third email, so there was some going back and forth, right? First they said Bulgarian courts, then you replied, no, 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 Italian courts. Then the other party said, no, 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 it's our terms and condition. And then you delivered. You never objected to their final offer. Why?
Thank you, Your Honor. I understand your concern, and I agree that our client could be more diligent with objecting to such an offer. However, following the clear requirements of the CJU case law and with applying our own contradictory jurisdiction clause, explicitly pointing also to the courts in Milan, cannot be established a consent between the parties if there is this first transaction. That would be unpredictable to then put all of the parties only to the court, which is place of the domicile of the applicant and not of the respondents.
So you're basically saying that the lack of your own diligence plays in your favor.
Thank you, Your Honor. That is also correct. It could be emphasized that way. However, neither was the applicant diligent to ask the opposing party, did we conclude a jurisdiction agreement or not? So neither party in the present case was indeed diligent when agreeing on jurisdiction agreement. However, if we apply the both parties' undiligence to the present case, leads to the default rules of the Brussels 1bis regulation. So therefore, if the court does not have any further questions regarding Article 25, I would move to Article 7 of the Brussels 1bis relied upon by the opposing counsel. The opposing counsel is relying on a colored drag case. However, as they emphasized by themselves, in paragraph 16 of that judgment, the court itself limited that decision to only where delivery took place in one single member state.
Perhaps before you develop this argument, how do you qualify this contract? Is it also, as the applicant stated, two contracts under one head, or do you consider it to be one contract governed by the same jurisdiction rules?
Thank you, Your Honor. So I would consider that a single contract. However, there were indeed two separate obligations, one for delivery of chairs and sofas and the other for delivery of the tables and cabinets.
With possibly different competent courts?
Yes, that is correct, as Article 7 applies to obligation in question, and therefore we apply Article 7 to the obligation in question in mind, and in the present case, tables and cabinets were not in conformity with the contract.
But is this rule of the obligation in question also with a contract of sale? Do you then not just consider it as a whole as a contract of sale with different components?
Thank you, Your Honor. That is correct. However, we have two different obligations in question. We have two different payments, two different furniture provided. Delivery took place in two different countries, so therefore it would be more reasonable to apply them as separate obligations under the contract. So accordingly, the colored drag case cannot be relied upon in the present case. However...
Yeah, sorry, one further question, because that's a very easy way out of colored drag, and I will not let you get out so easily. Indeed, the case was about a single member state, and the court made that important precision in the operative part of the judgment, because that was the question which was put to it. In preliminary references, we try to stick to the questions that are put to the court. However, in paragraph 30 of the same judgment, the court very clearly says that the first indent of Article 5.1b determines both international and local jurisdiction. So I would be able to deduce from that that judgment actually would apply also when you have deliveries in several member states. Wouldn't you agree?
Thank you, Your Honor. I understand your concern. However, I would also like to point out the following case law of the CJU that specifically dealt with situations where there were multiple places of deliveries, which shows us the view of the CJU on such situations. So therefore, I would like to refer to wood floor judgment, where the place of performance was in different member states. So the question was, can the same logic apply? So I would like to emphasize the Advocate General opinion Trstaniak in that case that specifically mentioned that allow the applicant to choose freely among multiple jurisdictions cannot be accepted, as that would undermine predictability and create a risk of forum shopping by excessively favoring the applicant, as they would possibly can choose from all of the member states where the goods were delivered and apply this to their jurisdiction clause. The CJU indeed followed that opinion and held that where principal place of performance cannot be determined, jurisdiction should lie at the court where party executing the contract is domiciled. So not the applicant's choice, but an objective connection. And therefore, if we apply this to the present case, in cases of sales contract, jurisdiction should lie with the court at the seller's relevant place of business. I would like to emphasize Your Honor's concern about the proximity of such place. In the present case, as I mentioned before, manufacturing took place in Italy. If we apply the seller's relevant place of business to the present case, the proximity principle is satisfied. And accordingly, I would like...
Before you fall back on that, you need to show this court that you're unable to identify the principal place of delivery, which you haven't done.
Thank you, Your Honor. Yes, that is correct. So principal place of performance should be, according to the color drag case, determined on the basis of economic data. So if we apply Article 7 to the present case to the obligation in question, which is delivery of the tables and cabinets, the delivery was equally split between Croatia and Bulgaria. We see that if we look to paragraph 11 of this case. So 3 tables and 3 cabinets to Croatia and the same amount to Rijeka.
Yes, indeed. So the court said you should take into account economic criteria in color drag. However, in later case law, the court added further factors and criteria which are relevant. Electrosteel, you should look at all the clauses of the contract, for example. So not only at economic factors.
Thank you, Your Honor. So we would then first determine, in electrosteel case, they specifically depended on an agreement under the contract. So the opposing counsel specifically relied upon just on the clause DAP Sofia, Bulgaria. However, I would like to emphasize that agreement that the half of the goods should be delivered to Rijeka is also an agreement between the parties under the contract, just as this is an oral contract. And to make a difference between a written contract and an oral contract cannot satisfy the predictability between the parties. So both of these provisions are determined under the contract, and therefore, if we apply this, the principal place of delivery cannot be determined.
And how do you address then the argument made that it's actually just a last-minute decision for practical reasons?
Thank you, Your Honor. So I would address this with the fact that neither of the parties emphasized any concern that they are not satisfied with that last-minute change. So again, it would be diligence of the opposing party to inform the other contracting party they are not satisfied with that kind of modification of the contract. Since that is not the case in the present case, the equally should be applied to both. So accordingly, if we apply this to the present case, Article 7 points to the court in Milan, Italy, where Tosca, the seller, has its relevant place of business. I would just like to emphasize that although wood floor concerned provision of services, Court of Justice itself clarified in paragraph 26 of that judgment that both rules for the contract for the sale of goods and provision of services have the same origin, pursue the same objective, and occupy the same position within the system of the Brussels 1bis regulation. I will now turn to the second issue concerning parallel proceedings between the parties. Mirroring the opposing counsel's argument, I will first demonstrate that the exclusive jurisdiction clause cannot be relied upon. I will then show that in light of this fact, this court, as the court second seized, should stay the proceedings. So the opposing counsel is correct that both the Brussels 1bis regulation and the CMR convention apply to the present dispute. However, as the opposing counsel, as the court noted, their application of Article 71 is one-sided. They rely on a Brussels 1 bis regulation where it supports their case while ignoring what is binding under the CMR Convention. Accordingly, it is true that in TNT Express case, the CGU clarified that specialized conventions only take precedence if they ensure objectives equivalent to the European Union law. However, the opposing counsel is wrong that CMR does not meet that standard. As Your Honor emphasized, Advocate General Emilio made clear that CMR jurisdiction regime is fully compatible. But to start from the beginning, under Article 31 of the CMR, jurisdiction agreements can only create additional non-exclusive jurisdiction agreements, while Article 41 renders any derogation from that rule null and void. So the opposing counsel relied that such jurisdiction agreements should be interpreted as non-exclusive. However, members of the court, that would directly go against the Article 41, which specifically states that any derogation from the convention is invalid. So accordingly, I would like to emphasize that the provisions of the Article 31 are fully compatible with TNT Express case. If I rely on the Advocate General against Sidiga, he emphasized that provisions of the CMR Convention are neither vague or uncertain. The applicant can still easily decide where to bring its claims, while the respondents can reasonably predict where it may be sued. Accordingly,
I would like to interrogate you there. This is precisely why I pressed the applicant to give me their strongest argument against AG Emilio's opinion. And I would like, they said legal certainty, and I would like you to react to that, but I'll just try to elaborate just a little bit on that. Because you're relying on the fact that under the CMR, there cannot be exclusive choice of court clause, no exclusivity. Now, part of the contracting member states' courts disagree with you. There is case law of national courts which disagree with you, which says the opposite, exclusive choice of court jurisdiction is possible under the CMR. So you have certain members or member states of the EU or third countries where that is interpreted as being possible, and others where this is interpreted as being impossible. Now, how is that compatible with legal certainty?
thank you, Your Honor. So I would like to emphasize that with the fact that the opposing counsel is relying on predictability to give priority to the Brussels 1 bis regulation. However, I would like to emphasize that according to the Brussels 1 bis regulation, main principles are sound administration of justice, preventing of irreconcilable judgments, and indeed to predict high predictability and to give the parties autonomy. So I would like to emphasize that Article 31 of the Brussels 1 bis enables all of these principles. It allows parties autonomy to conclude non-exclusive jurisdiction agreements and ensures that provisions of the CMR are predictable. So neither of the principles, Madam President.
Yes, I was just wondering, you know, this article that gives priority to the exclusive jurisdiction clause was actually entered into force to prevent this race to the court. And if you have this jurisdiction clause, it should take priority. Now, this race to the court is exactly what is happening under the CMR. And why is this? Because you have normally a limitation of liability unless there is wrongful conduct. And so the legislations differ on deciding whether there's wrongful conduct or not. Like in the Netherlands, there's almost never wrongful conduct. So it's very important that you go first to a court, establish that there's a limitation of liability, and then waive this judgment, which is precisely what the new Brussels 1 regulation wanted to prevent. So would that not make a strong argument to say, yes, we should give in this respect priority to the Brussels 1? And of course we are aware of the opinion of the Advocate General, but we're also aware that it's not always followed by the court. So what are your views on that?
Thank you, Your Honor. I understand your concern that there could indeed be an issue of torpedo actions, or to go to the to not rely on exclusive jurisdiction clauses. However, I would like to emphasize that respect needs to be given to the international agreement that the countries made between themselves. And if that agreement renders exclusive jurisdiction clauses, then European Union cannot go against such agreements between the parties. So accordingly, it would indeed be unfair if there was valid...
Well, it can. It can. This is what the court said in TMT. Under certain conditions, the international convention would not apply. And as Madam President just pointed out, if there is one big enemy of European private international law, this is the phenomenon of race to the court. And the Brussels regulations do everything possible to prevent that. So how does not that undermine the very logic and general economy of the Brussels regulation?
Thank you, Your Honor. So I would like to, being aware of my time, I will answer the question and then conclude with which court to stay the proceedings. I would like to emphasize there is also a very important principle under Brussels 1bis regulation, that is mutual trust between the member states and also between the courts. So if there is no valid exclusive jurisdiction agreement under the specialized convention, we need to trust the court in Rotterdam that the judgment they will render will be correct and that there is no torpedo actions.
Well, sorry, just one last thing really, but this is precisely the issue here. How can I trust another member state's court on how it will interpret the CMR if there is no uniform interpretation of the CMR because different members interpret it in different ways? There's no authoritative interpretation because precisely the ECJ has no jurisdiction to interpret the CMR. So this is precisely why the mutual trust is undermined.
Thank you, Your Honor. So I would answer that question with the fact that Article 41 against itself renders exclusive jurisdiction null and void. So it is most predictable to all the courts to follow the provisions of the Convention and rely on Article 41, and that would be most predictable if every contracting state sticks to what they agreed upon, rather than now allow exclusive jurisdiction clauses to be relied upon under the CMR. So accordingly, since exclusive jurisdiction clause cannot be relied on the present case, nor can be the Article 31 of the Brussels 1bis regulation, which gives priority to the prorogated court. Even if this court interpreted that provision as non-exclusive, Article 31 of the Brussels 1bis does not apply to non-exclusive jurisdiction clauses. Therefore, this court should stay the proceedings. Unless I can be of any further assistance to this court, this concludes my submission. Thank you.
Let us hear the arguments on the applicable law. And let me start by asking you the same question. What is the relationship or the priority rules between the SICG convention and the Rome I regulation?
Thank you for this opening question. And of course, thank you for welcoming me here between this honorable court, Madam President, and our members of the court. Respected representatives of the applicant, I wish you all good afternoon. My name is David Golop, and in the upcoming 14 minutes, I'll address the third issue of the applicable law. Now to begin answering your question, in our case, all the conditions set in Article 1, 2, 3, and 100 of CISG are fulfilled. That's why the CISG applies prima facie. On this point, we also agree with the applicant. It is really important to establish this, and of course, thank you for the question. As said, applicant is right that CISG applies prima facie. However, their conclusion that they successfully excluded the CISG under Article 6 is wrong. CISG will only be displaced if the applicant proves that they successfully incorporated their standard terms which contain a choice of law clause that excludes the CISG in this contractual relationship. Absent such valid exclusion, the CISG will govern this contract. Against this backdrop, I will show that the applicant's standard terms were not validly incorporated, and the reasons for this are two. Firstly, they provided two contradicting choice of law clauses, and secondly, the choice of law clause provided in the standard terms provided via an indirect hyperlink likewise does not satisfy the requirements of Article 8 CISG.
But they clearly stated that they're only referring to the explicit reference and not to the hyperlink. So perhaps you can only address that point. As the applicant clearly, I asked this question about the controversy, whether it was just Bulgarian law or Bulgarian law with the exclusion of the CISG. And so they explicitly answered that they do not refer to their general terms and conditions, but only to the explicit reference to the Bulgarian law. So perhaps you can just answer that.
Of course. Thank you very much, Madam President, for the question. Yes, now before the court, when the proceeding has already begun, of course they clarified. However, the position of the respondent is that this is not the right time for clarifications. The contract should be clarified before its conclusion. And of course, I will also address the issue associated with the standard terms provided by hyperlink. Nevertheless, the respondent feels compelled to also address this first issue. Turning to this first issue, to establish the rule, for the application, for the incorporation of the parties' standard terms into the contract, two conditions under Article 8 have to be met. First, standard terms have to be made reasonably available to another party, and secondly, another party has to accept these standard terms to form part of the contract. The issues are associated with this first criteria, that is, the applicant did not reasonably present their standard terms to the respondent. To address this issue of provision of double contradicting choice of law clauses, again, now they did in fact clarify that which one they meant. However, during the conclusion of the contract, as if I may guide you to the case, paragraphs 3 and 4, the contradiction is apparent. One choice of law clause contained in the footnotes states Bulgarian national law should apply. Here we would like to emphasize that CISG is a part of Bulgarian national law, since Bulgaria is a contracting state to CISG. On the other hand, the choice of law clause contained and provided via indirect hyperlink provides for the Bulgarian law with exclusion of CISG. The contradiction between these choice of law clauses could not be more apparent. This contradiction also creates an ambiguity, as it is unclear which of these two choice of law clauses the applicant intended to include. Do I sense a question, Your Honor?
Yes. When you speak of the inconsistency of the two choice of law clauses on the Bulgarian side, but they are partially inconsistent, are they not? I mean, they are only inconsistent to the extent the Vienna Convention has useful rules, so to say. I can't come up with a good example now, but I can imagine that there are issues of substantive law that are not covered by the Vienna Convention, but they are covered by other rules. I mean, it follows clearly even for the formulation of the court of the choice of law clause on the Bulgarian side, when they say Bulgarian law with the exclusion of this. So I wonder whether we are talking now about the application of the Vienna Convention, or are we talking about application of Italian law, including the Vienna Convention? It's not the same thing, because it leaves, as I said, a space for other issues that are kind of by default applied by national law. So I don't think there is inconsistency. You could say, yes, Bulgarian law applies. It has been agreed on, let's assume, by the parties, unless it is a question governed by the Vienna Convention. Would that be the position of the respondent?
Thank you, Your Honor, for the question. That would not be the exact position of the respondents. The respondents stand on the position that there is apparent contradiction. Of course, the CISG does not govern all the matters in this case. However, for the particular issues that it does govern, it should be applied. And one of the main questions before this court is whether the party successfully excluded the CISG. And the position of the respondent is firm that this contradiction of these two choice of law provisions, both are choice of law provisions, is contradictory, creates ambiguity, and this ambiguity should be resolved using the contra preferentum principle, meaning that it should be interpreted not against the interests of our client, but rather against the interests of the drafter.
And this leads to the application of Italian law or immediately to the application of the CISG?
Thank you, Your Honor, for the question. Exclusion of CISG and the determination of which law applies are two separate questions which will also be addressed.
But I mean, the fact that you say due to this discrepancy in this footer, we're not going to look at the footer, what is the consequence of it?
Yes, thank you for your question. Now, even if the court is consistent and takes the opinion that this quite apparent contradiction is not problematic, there is another issue associated with the applicant's standard terms, those provided via a hyperlink, and that is that they have not been provided in an appropriate way. So the conclusion regarding the question whether the applicant did, in fact, validly incorporate their standard terms should not change. Here, the relevant provision of CISG is Article 8. Article 8 in itself is a blanket provision that must be filled with the relevant legal theory, and here the most authoritative commentary on CISG by Schlichting and Schwenzer states, and I quote, "The presentation of the standard terms text on the internet is furthermore sufficient in cases in which the contract of sale is concluded via individual emails, if the offer's email contains a hyperlink that leads directly to the standard terms text. If such a direct hyperlink is missing in the email, the recipient's mere possibility to search for the standard terms text on the sender's internet homepage is insufficient."
But is then your contention that the first email of Royal is an offer?
Excuse me, could the court...
Yeah, sorry. Is because the reference you just read states or starts by saying if the offer contains an hyperlink. So my question is, what is the offer in this? Who made the offer?
Thank you very much. The offer was made by Tosca.
Okay, so it actually has no bearing.
Thank you for this sharp observation. I cited this particular paragraph not to show or to discuss which was the first or the last offer and so on, but rather to show which conditions have to be fulfilled by the party in order to claim that their standard terms can be considered validly incorporated into the contract. And under this Article 8 provision, one of the necessary provisions is that direct link is provided to opposing party. This was clearly not fulfilled in our case, as the applicant's email of May 26th did contain a reference to their standard terms. However, this reference was not provided via a direct hyperlink. The link was indirect, as evident from paragraphs 3 and 4 of the case. The absence of direct hyperlink means that their standard terms were not provided in a reasonable way and therefore could not be considered part of the contract. Again, since successful inclusion of their standard terms, which included the choice of law clause that excluded the CISG, was the only way in which the CISG could be excluded in this contractual relationship, the CISG clearly applies. Now, should the court not follow even this argumentation, then the situation when both the applicants and the respondents' standard terms would be reasonably presented to another party. In this case, the situation that we know as a battle of the forms would arise. There is many doctrines by which the court may address this issue. However, the position of the respondent, as well as the most prominent authorities on CISG, including Schwenzer, including the AC opinion on this matter, state really clearly that in these cases, knockout rule should apply. In a nutshell, knockout rule means that the contradicting clauses in each set of standard terms should be displaced to the applicable dispositive rules. In our case, there is apparent contradiction not only in the applicant's choice of law clauses, but there is also apparent contradiction between our client's choice of law clause with each of their choice of law clauses. Applying the knockout rule in this case would mean that these contradictory choice of law clauses should cancel each other out, leaving the provisions of CISG to govern. So even, to conclude this argument, even should the court decide that both parties reasonably made accessible their standard terms, the conclusion should not change. The CISG should nevertheless apply. I sense a question.
Yes. Is my face so clear? Yes, I was just wondering, this knockout rule, who decided that this rule exists? So you refer to authority, but there's also case law, or there's, because you know, there's also the first rule, the last shot, the first shot rule, the last shot rule, the knockout rule. I mean, which one should we choose? I understand that you like the knockout rule, but there's also, well, a lot of authors who plead for the last shot rule and who say that that's most consistent with Article 19 of the CISG.
Thank you very much for this question. Now, being aware, under the clarification number 3, it is stated we should not use the national case law. Nevertheless, there is really strong case law supporting the use of the knockout rule, and that is the powdered milk case by the German Supreme Court, which is really dominant authority in the European legal space. And so, powdered milk case, again, being aware, I should not bring up this judgment, but to the interest of the court. It was adopted in 2002, and I will read you a paragraph from the judgment, that the question to what extent collateral general terms and conditions become an integral part of the contract where the CISG applies is answered in different ways. However, according to the prevailing opinion, partially diverging general terms and conditions become an integral part of the contract. That clearly supports the knockout theory.
But that means that a contract has been concluded because there was consensus about the essential elements. But how does that correspond with Article 19 that says that you make a counter-offer if you change something important, like the dispute settlement? And I presume if you change the choice of court or the choice of law, that might be considered something important. So what would be your views on that?
Thank you very much, Your Honor, for this question. It is true. Under Article 19, material alteration of the contract means that it constitutes a counteroffer. In our case, the position of the respondent is that actually the contract was concluded on May 26th by the applicant, as they stated that they accept our offer of price, payment, delivery terms, etc. They stated under our terms and conditions. However, as really demonstrated quite clearly in our opinion before, is that their terms and conditions were not reasonably presented. And since they were not reasonably presented, in our opinion, in this case, this material alteration did not occur. To address the rest of the issues also raised by the court raised the issue of the last shot doctrine. Of course, we agree with the court. The last shot is one of the leading doctrines as well. It has substantial support also in legal theory. However, as stated, the prevailing doctrine is still knockout rule, and I'll explain why. With the last shot, first of all, none of these doctrines can really be found in any of the provisions of CISG. CISG is an old convention from 1980s, meaning it has substantial, let's say...
The world has changed, yes.
Meaning that sometimes there should be other tools to fill these gaps. And one of the tools is the use of analogy that is possible by applying Article 18 and 19, and from application of analogy of Article 18 and 19, we could derive the last shot, and that's also how it has been determined in the past. On the other hand, the knockout rule is derived from the principle of good faith found in the Article 7 of the provision. So, stating that the last shot has a basis and the knockout rule does not have basis on CISG does not really stand firm. Additionally, there is plenty of issues related to the last shot rule. Just to name a few, actually, the main issue with the last shot is that it creates a substantial inequality between the parties' rights and obligations. It creates situations when one party basically gets all running for them. All their terms and conditions are included into the contract, while the conflicting provisions of another party are left out. This especially in cases when there is not really clear how the contract was concluded, as in our case, there was a long correspondence, does not really fit well in the opinion of the respondent. The knockout rule is, on the other hand, fair to both parties. It's conflicting provisions just cancel each other out, and uniformly for both parties exactly the same, the uniform substantial law is applied. And the position of the respondent is that that's the most just decision that the court could take when it comes to the applicable law.
So your argument is that the contract has been concluded without any agreement on the choice of court or choice of law?
Exactly.
Okay, and then what happens?
If no agreement has been concluded regarding the parties' terms and standard terms, that means, since again, the only chance for the parties to exclude the CISG was if the applicant successfully incorporated the standard terms, and they were not included, that means that the CISG governs this contract.
Okay. Voilà.
Thank you for your
Perfect.
attention.
Yes. Time for the rebuttals. For the applicants.
Madam President, Your Honours, the respondent claims that the terms and conditions should be clarified before the conclusion of the contract. This was one of the points that they mentioned. However, this is not true, as the contract, as we submitted, was concluded before with Mr. Medvedev's email, meaning that this requirement is satisfied. And second, this view completely disregards Article 29 of the CISG, which provides that parties could modify their agreement, even if we assume that the contract was concluded with the issuance of the letter of credit. It still disregards Article 29 of the CISG. Also, the respondent maintained that the terms and conditions were not reasonably communicated. However, in view of paragraph 4 of the case, they were actually contained also in the hyperlink in the very email with that Mr. Medvedev expressly referred to those terms and conditions, and also in contradiction with what the respondent argued, the hyperlink is contained in every email.
Okay, thank you. It was a very short time frame for the rebuttal. And the surrebuttal.
Madam President, honorable members of the court, mirroring the opposing counsel's argument, I will make a one-fold submission in our surrebuttal. I would like to emphasize that applicants' arguments would render the CISG ineffective in practice. If the courts were too quick to find the exclusion, the purposes of the convention would be defeated. I would like to emphasize that if both parties attempt contradicting clauses regarding the exclusion of the CISG, the provisions, the purposes that allow the party autonomy to be truly respected should be that CISG should indeed govern the contract. That is the most predictable for the parties if they include clauses that are contradicting. This is precisely where the principle in dubio pro conventione applies. In cases of doubt, the CISG should not be pushed aside. Accordingly, since the opposing counsel did not contradict either our submissions regarding jurisdiction over Tosca, neither our submissions regarding the fact that this court should stay the proceedings. I would just like to emphasize that the Brussels 1bis regulation provides a frame for jurisdiction that must be highly predictable, and that requirement is not optional. To allow predictability of Tosca, we kindly ask this court to decline jurisdiction under Article 25 and to respect the CMR Convention, that is specialized convention which renders exclusive jurisdictions ineffective. Accordingly, if I just emphasize the Advocate General Emilio Engensidige case, as he emphasized, no specialized regulation, no specialized convention that departs from the regulation could ever be applied in intra-EU relations if we disregard the CMR conventions. Accordingly, members of the court, with that in mind, I will close my rebuttal with inviting this court to decline jurisdiction over Tosca, to stay the proceedings against SWIFT, and to apply the CISG between the parties. Thank you.
Okay. Thank you very much. I think this closes the debate. So thank you very much for this lively discussion. You gave us a lot of food for thought. So we will now enter into our deliberation and we will render judgment on a later date.
Honorable members of the bench, dear participants, dear friends. You know, 3 days ago, I have officially this year's edition of PAX Moot 2020, and now it's my honor to lead you all to the closing of this unforgettable event. I hope very much will remain with you forever. Please allow me, before I say a few words, to present to you our page, because I think you deserve the students to know who we are. I will begin by presenting Judge Ilse Hohenberg. She's Judge at Supreme Court of Cassation in Belgium, and also she's an academic active, very much active in the field of private international law. I'm sure that you have realized that. Next to her, to the right, it is Alexander Kurnezov. Alexander Kurnezov is the Bulgarian judge at the European Court of Justice. So what you experience now, it's maybe what you do every day over there in Luxembourg. You can text. And to the left, this is Professor Michael Porter. I'm sure that most of you, I'm sure all of you know him. He is the doyen of the private international law worldwide, and maybe one of the most referred authorities in our field. So we are more than delighted to have you here with us today. So I'd like expressly to thank you all for being here with us in our judicial powers, and to be able with you to enjoy this final. And it was a remarkable final. I've never experienced that difficult final so far. I was in almost all finals once we started with our colleagues 99 years ago. So really, congratulations, what you have done is really, really impressive. I'm very happy that I was not in the position of the council. And also my husband, who is a lawyer, told me, wow, what is going on here? Luckily, our Jews are not like that. After saying this, please allow me just once again to thank you for coming to Bulgaria, for joining this competition, for daring to work so hard to face this complex case, indeed very complex. I told Alice that I wish him that he will be reached by the request very soon, and he has to decide in very specific period scenario on the issues that you are pleading as applicants and also as respondents. And yeah, I said a lot, but maybe it's very important just to refer to Richard Kipling, who said, trying to fill the unforgiving minute with the 60 seconds worth of distance on. So learn the time you have, enjoy it like you have shown us you're able to, and stay what you are now. Ambitious, intellectually challenged, and really high professional. Because what expects you is what you have faced these days, so you experience part of your future. You will be under pressure, you won't know the answers, you will face complex problems. It won't be certain or predictable, so you know what about predictability. You may not face this feeling of feeling insecure or maybe sometimes tricky, but this is what we do. This is our field of work, and it's also very rewarding because it provides you the opportunity to understand, to convince yourself, and then you are able also to convince others. So this is a great pleasure to convince others, then to find your ground, and then to win it. And of course, what winning is subjective. You can win as what is standard and as good as winning, but you win for minimum work when you are not rewarded with the first prize because you prepare to stay focused and to continue going further with your plans and be ready again to fight. That is more difficult than just enjoying the rewards. Something that nowadays is self-evident, that's the most important, but it's not. So why I finish these wise words, I would like now to give the floor. Once again, thank you to all of you, to our judges, to our colleagues from the different projects, to Marta, to, sorry, that I'm referring not with your name, Marta, and Stefan, to all our colleagues from the project, Tanya, Julia, our colleagues from Ljubljana, from Barcelona, and from Aspen Institute, Professor Vesna Lazic, who is the author of the case, we should express. I would like to thank my team, Tracy Toma, our former participants and PAX, our Bulgarian judges that joined us in the finals in the previous rounds, and of course our dean and vice dean that were very supportive over here. So it's possible to have these PAX here in Sofia. We are really thankful and grateful to all of you from the moment of my heart and from our hearts.
Really indeed. It's great. You're welcome.
So, without further ado, we will announce who won the different awards. As you know, there are 2 awards. An award for best leads, an award for best organist, and an award for the winning team. Of course, the judges of the final will announce the winner of the winning team of this PAX Moot Court. But we will start with the award for best winning leads, and I would like to invite Vesna and Lisa to announce the winners of this category.
So thank you very much, Chairman, dear participants, dear colleagues, and dear friends. This is a moment that the awards will be distributed to those who did the best jobs here. So the first part of the job that you had to do was to prepare written memoranda. As a institute is a very proud team member of the PAX Moot. And so, considering that as institute is not faculty, is not the law faculty, so we don't have a team. So as institute then has this some kind special position for in preparing the case and also in evaluating the memoranda. And this year, with great support from my former moot coach in studies and therapy and good friend with an Danish. And that's the moment is now that we are going to announce the best, Lisanne is going to announce the best memoranda and the votes for the best memoranda.
Yes, thank you. Well, it's a great honor to announce the winning memoranda. Before I'll name the winners, I would first like to name 3 teams who won an honorable mention. They were just 1 point short, but that's not what is important. What is important is that they wrote very good memoranda. These teams were Singapore Management, University of Madrid, University of Antwerp, there were 2 teams with the best memoranda, so 2 teams who won first place, University of Warsaw, the other team is the University of Ljubljana.
The award for Best Artist will be presented by one of our executive secretaries, Maya.
We are so delighted to see you all here. It's been a lot of work, intense work. It's so rewarding to see you all here. So now I'm going to announce the speakers. So I'm going to start with the 3rd place. Okay? So the 3rd place goes to Benedetta Gagliardi. Now the 2nd place goes to Lara van Hoeken. The 1st place goes to Chloe Xing Chia, Singapore Management University.
So now, thank you. All right, then I'll give the floor to the presiding judge of the last bench of the final, our judge in the Belgian Supreme Court, Mrs. Ilse Kallenberg.
Thank you.
First, of course, a word of congratulations to all of you. What an incredible ride it has been. I think from the first time that you read the case till now, hearing the pleading in finale, I've heard from the other judges that the level was very high, and I can only concur. I mean, I've been in this moot court for a couple of years, and I found this year to be a particularly difficult case. Thank you. I would love to hear how you would solve it and defend it. But of course, it has to be a challenging case to make it possible to make arguments in different directions. So in my view, all of you sitting here in this room, you are winners. I mean, you made it this far, you delved into a case, you experienced a bit what real lawyerly life would be. And I can sincerely say, sitting for almost 25 years on the bench, that I rarely see lawyers so well prepared and so knowledgeable about the case, so able to answer difficult questions. So congratulations, and that extends to all of you. But of course, I'm here to make a final decision between the two competing teams in the final. And I know I have said it a couple of times, but this year it is especially true that it really was almost impossible to choose. We had quite a lengthy deliberation just because of this reason, and so we pondered the possibility of not choosing. Unfortunately, that's not a choice a judge has. Ultimately, he or she has to choose, even if it's with a heavy heart. But no further ado, so we decided, basically because of the ability to respond quickly and adequately to the very difficult questions, I agree. So we had a very tiny preference for Ljubljana.
Within the Antwerp team, to make that, I think when I took the floor during the opening ceremony, I thanked a lot of people, I mentioned a lot of people, but I forgot to mention my own colleagues. So that I did first say. So I especially thank the team of Antwerp consists out of 4 people. Johan Mees couldn't make it this year, there is also Tyler Klinker. And then we've also the mastermind, the spider in the web, the PAX Moot Court, my colleague Marta Pertigas, who will be.
Forgotten. The spider of the web is of course always hidden somewhere, and basically I'm here to say a few last words on behalf of a very big group of people who work on this project throughout the year. And this round started already in August of last year, when we were already insisting that we would have to come up with a case, and as was mentioned for you, then the work started, and today hopefully you will be able to put an end to this critical round and relax and take a moment also to appreciate all the beauties that we've seen only in passing these few days. And on top of that, we have sunshine, so really, it is really time for us to enjoy Sofia. Yes, a lot has been said. I would like to join all the words of appreciation that have been mentioned for our hosts. You've done a fantastic job, and to our judges who came from many different places, who had to face Lufthansa strikes and many other difficulties. And even I heard that one of our judges today had a clash and was invited to 2 Moot Court competitions and chose this particular one. So thank you. Yes. And at this point in time,
I guess, perhaps not for this group of students, but for you to spread the word, because once you are part of this competition, what we would like is for you to remain part of the PAX family, of the PAX community. And that means that we count on you to spread the word, pass all your knowledge for the future cohorts, for the younger students back at home. And part of that is perhaps telling them that next year they may also go to a very nice sunny destination. It happens to be also the city where I was born. And so I would like to announce that if all goes well, and subject to the European Commission funding, which of course we also thank very much for making this possible. Next year, if all goes well, we will meet in Barcelona. See you.